part of the handbook, right?
That was a two-page
It
thing,
was the
Yeah,
cyberbullying of the
right.
handbook.
and there was only one copy of it. I didn't give the judge one copy.
And I didn't pay attention to
We made it full exhibit.
Yeah, I know you did. I just can't find it.
If you can't find it later, you let us know, okay?
All right.
It might be up there.
Oh, you might have walked out.
All right, perfect.
I'm not afraid you walked.
You may have.
I wasn't paying attention. Yeah.
Are we all set?
Yeah, yeah.
Okay. All set?
Yes, thank you.
Okay. Laura, you all set?
Oh, you probably doesn't have it.
Make a difference one way or the other.
I have a copy. Do you want it?
Well, we've got plenty.
Yeah, okay.
Now we'll have two copies. That was one, right? I don't know where it went.
Is it up there on the phone?
We don't look, because that was Jay.
I'm thinking he walked out with it in his hand.
It was full, yes. George, you can look through this if you want. There's just the exhibits in there.
Okay, she has the one with.
Judges ready, we're going to go.
Thank you.
Thank you.
Ladies and gentlemen, please rise for the honorable court. Merrimack County Superior Court is again in session. Please be seated.
We will be resuming testimony in just a moment, but before we do, I just want to say directly to the members of the press here and on the record that this morning I issued an order granting a motion for instruction to media about photographing defense materials. That order, as I say, was granted, and the substance of it was communicated to the representatives who are filming. Specifically, that my order to the media is that it may not zoom in, photograph, film, or otherwise make efforts to capture or view defense materials. I have been informed over the break that the live stream zoomed in on the materials, the notebook on the defense table, then zoomed in on the materials on the state's table, and then zoomed out. I want to make it very clear that that is unacceptable. And if I get further reports of that on the live stream or anything else, I'm going to direct that the cameras be removed from the courtroom.
Your Honor, is it possible to incorporate the state's table into this order that you've issued
Granted,
as well?
and the defense and the press is on notice.
Thank you.
You may resume your intervention.
Thank you, Judge.
Court, once again, I have failed to strike the ID on an exhibit. I would move that the ID be stricken on 1M, which is Attorney Rancourt's affidavit regarding the intranet research, and that be marked as a full exhibit.
Any objection?
No objection.
Granted.
Attorney Rancourt, we were speaking about the motion to set aside verdict that was filed by Attorney Zagangori and Attorney Carney. I'm going to return to that topic.
Okay.
And you indicated that you were aware of their intention to file that pleading?
Yes, I was.
I believe you answered this before, but just to be sure, when did you become aware of the intention to file that pleading?
There was some discussion following the verdict. I believe it was still in the courthouse.
Were you involved in the drafting of that motion?
Well, originally, no. Well, no, I guess is the answer to the question.
Originally,
The drafting, no.
Can you expound on that?
So, at the time that the verdict had come in, I had just started, I had a law clerk from the University of New Hampshire School of Law working with me, and so I had offered that day or the next day, I'd sent Attorney Carney an email offering to have my law clerk conduct any research that might have to be done for the motion for new trial. Specifically, I had offered that he could do legislative history research because in the state of New Hampshire, as we all know, you can't always do that online for New Hampshire statutes, especially older ones. So sometimes you have to go to the State House. It can be difficult for them to drive up from Boston to do that. So I had said I could send my law clerk to conduct legislative history research or do whatever you might need. Just let me know. The response to that email was, hold off. We we're going to strategize on the motion. If we need anything from you, we'll let you know.
And was there any follow-up to that hold-off email?
Well, eventually, yes.
And what was that follow-up?
So eventually, right before the motions were filed, I received another email from Attorney Zagangori asking me for legislative history research, which was weird because I was told not to do it. But fortunately, I did do it. So I had it.
And did you provide them with that research?
I did.
May I approach the witness, Judge?
Yes.
George was just reviewing it to see if the missing issue document was
I'm showing
in.
you two documents. They've been pre-marked as for ID as exhibits 15 and 24. Can you take a look at those and let me know when you're prepared to discuss them?
Okay, yes, sorry, took me.
Can you tell me what those are?
So, exhibit number 24 is an email exchange between myself and yes, it was an email originally from me to Attorney Carney, Attorney Zagangori, and Attorney Fullerton, where that was the email where I had offered to have my legal intern conduct the legislative history research, and then Attorney Carney's response, could you hold off from doing any work on these issues for now? I'd like to begin with a strategy meeting to decide how best to approach this and not duplicate efforts. And then I had responded telling them that they might not be able to do legislative history research online, just alerting them to that.
And which document is that?
That was number 24.
And as to number 15, can you tell me what that is?
Number 15 was what originally began as an email correspondence between myself and Attorney Zagangori, copied to Attorney Fullerton, where we were talking about the deadline for filing a motion to set aside the verdict. And then at some point he responds and says, did your law clerk have a chance to look at the legislative history?
Judge, I would move to strike the ID and mark both item 15 and 24 as full exhibits.
No objection.
Granted.
Thank you. I think we've established at this point that you were familiar with the research file that was contained in the file provided to you by Attorney Carney and Zagangori.
Correct?
Did you review that file for any documents, and did you find in the file any documents that would be on point for the motion to set aside verdict?
Yes, so we saw, I believe we saw some research on the motion to set aside verdict, but I know we saw drafts. There were numerous drafts of the motion to set aside verdict that had gone back and forth between Attorney Fullerton, Attorney Zagangori, and ultimately Attorney Carney.
Judge, if I have just one moment.
Yes.
I'm sorry, Judge, I'm going to take a back step. May I approach the witness again?
Yes.
I'm showing you what has been pre-marked as for ID as number 25. Can you take a look at that?
Okay.
And can you tell me what that is?
This was the law clerk who had been working for me at the time, whose name was Mike DiPietro, had sent me an email attaching a memo what he had done, what research he had done on the legislative history of that statute. And then this is an email forwarding that memo from me to Attorney Rancourt and Attorney Fullerton, and then some back and forth. They had asked for the materials that my law clerk had referenced and wanted to see the actual legislative history that he had found.
I want to focus on the dates of those for a moment, specifically speaking to numbers 15, 24, and 25.
Okay,
I believe the item I just handed you is number 25, is that correct?
that's correct.
Judge, I would move to strike the ID and mark as a full exhibit, number 25.
I have no objection.
Thank you.
Granted.
Attorney Rancourt, are you familiar with the date that the jury returned its verdict?
The 28th, the 27th?
In August, is that accurate?
End of August, yes.
And I think that email reflects the deadline by which you must file a motion to set aside verdict.
Yes, we had some back and forth about 7 days or 10 days and what the date would fall on, because part of it was a weekend, and so, yes.
So I want to focus now on the dates that these emails were sent. Can you indicate for the court the date that you sent the email offering to do the legislative research?
It was on Monday morning, August 31st. I think it was that following Monday morning.
And can you tell me the date on which Sam responded and said, and actually followed up and said, do you have that research?
Wednesday, September 2nd.
And I would draw your attention to number 25.
Okay.
Attorney Zagangory sent a follow-up email asking for copies of the materials. Can you tell me what date that was sent on?
On Friday, September 11th, Attorney Zagangory asked, does your office have copies of the materials that your clerk references in the memo?
And are you aware of when the motion to set aside was filed?
I think they asked for an extension. So if I recall correctly, it wasn't filed within the 7 days or 10 days or however you calculate it. So I think they asked for an extension. I don't remember exactly when it was filed.
Fair to say that all of this research and the request for research was done post-verdict?
Correct.
And I'm going to return now to the research file that I started to approach before I realized I'd forgotten an exhibit. May I approach the witness, Judge?
Yes.
Just take a look at those and let me know when you're prepared.
Okay.
Can you tell me what those documents are?
These are screenshots, essentially, of parts of Attorney Carney's file. Exhibit 17 is a screenshot of the various iterations of, and again, I'm sorry, my computer knowledge is lacking, so exactly what you call it, I don't know. But when you look in their file under drafts, this is a screenshot of what you see as it references the motion to set aside the verdict, and there were various drafts of it and dates on which it was saved, and again, the initials of who apparently had worked on it. Exhibit 18 is, might be the same thing.
Did I duplicate?
Oh, no, there's different drafts on here. Oh, no. It just captures more. So there's some opposition to set aside verdict, timeliness draft. So apparently, so in Exhibit 18, to be clarified, there was some research or response to what the state maybe had filed, is the way I interpreted it. And then Exhibit 19 is if you click on properties or property details of a draft, it will tell you who authored it, who saved it last, how many revisions, and when it was created, and that's a screenshot of that.
So is our documents 17 and 18 the only research you found in the file provided to you as to the motion to set aside verdict?
Yes.
Was there any research with an earlier date on this specific issue?
Not that we found.
And as to document 19, it indicates at the top, motion to set aside verdict, draft 1SZ.
Yes.
Based on your review of the file, what does SZ stand for?
The way we interpret their file, that would be the motion to set aside the verdict, the first draft, draft 1, SZ in paren would indicate that Sam Zagangori had created it.
And are you able to read from that document or able to tell from that document the date that was created?
It says content created on September 16th, 2015 at 10:56 a.m.
And fair to say that that was after the verdict?
Correct.
Judge, I would ask that the ID be stricken on 17, 18, and 19 and that they be marked for full exhibits.
I have some objection to this, Your Honor. It's my understanding, again, I don't claim to be a computer expert either, but what we're looking at is a date that's modified. It doesn't really tell us when this was created, when it was accurate. I don't know that these dates are necessarily accurate and that Attorney Rancourt is in a position to testify to the statement that she just made in regard to that it was created on September 16, 2015.
I understand your point, and that would go to the weight and perhaps something to inquire of other attorneys, but I don't think it affects the admissibility of the exhibit.
And I have no objection to my point being noted, Your Honor.
Okay, so the motion to strike is granted.
Thank you. Attorney Rancourt, I want to be clear, and perhaps I wasn't. The date 9/16/2015, that's on document number 19?
That's on document number 19, but it also appears on document number 18 at the bottom of the page.
And does the document, does the reference on number 18 reference, let's just write that, let me come up with an appropriate way to ask this question. Does the reference on document 18, is the screenshot that is document 19 the details of a document that's on page 18?
Yes, so if you, at the bottom of document, if you're looking at document number 18, at the bottom of the page, the motion to set aside the verdict, draft 1, SC, if you click on the details of that document, you get the screenshot, which is number 19. But then, so the next, above, if you move up on document 18, you start at the bottom, and that's the draft 1. Then there's a draft 2 by Sam Zagangori, and then it says date modified 9/16 for draft 2. Then there's a draft 3, date modified 9/17. So it would appear from their file that as you revise documents, that they were saving them as different drafts. So you could look back and see where your drafts had been.
You indicated a moment ago that you believe that the defense filed a motion for additional time to file the motion to set aside.
That's my memory.
Have you reviewed that document?
I don't remember. I remember seeing it. I haven't reviewed it lately.
Can I approach the witness, Judge?
Yes.
I'm handing you what has been marked for identification as number 9. Please review that document.
Okay,
Do you recognize that document?
I do.
Is that document located in and among the file provided by Attorney Carney and Zagangori?
It was. That was where we found it.
Okay. And can you tell me what it is?
It appears to be a memorandum by Attorney Fullerton to Attorney Carney and Attorney Zagangori regarding timeliness of their motion to set aside the verdict and whether or not it appears to be research based upon what the state's objection had been to the pleading that they had filed.
Fair to say that one of the objections that the state raised is that the issue had not been preserved because there had not been a motion for directed verdict?
Correct.
And is that memo basically trying to save their motion to set aside verdict?
Correct.
And can you tell me the date on that motion, on that memo? I apologize.
October 13th, 2015.
Thank you. I would ask that the ID be stricken and that it be marked as a full exhibit.
No objection.
Granted.
So you referenced earlier that on the morning that you had the conversation about the jury instructions, that you had been there to have about the DNA, that you had been there to have a conversation with Owen, that you had been called to court.
Right, I had been requested to come to court to meet with Owen.
Can you tell me why?
I learned during the lunch break that day that Attorney Carney was advising Mr. Labrie not to testify, and Owen was asking my opinion.
To be clear, this was about his testimony at trial.
Correct.
And did you meet with Owen?
During the lunch break, I met with Attorney Carney, Attorney Zagangori, Mr. Labrie, and I believe his parents. And Mr. Carney laid out his reasoning. And then later that evening, after court had adjourned for the day, I met privately with Mr. Labrie.
So you were part of the conversation during which Attorney Carney was encouraging Owen to not testify at trial?
Correct. I mean, apparently there had been another conversation between the two of them prior to that, but then I was present at another meeting with Attorney Zagangori, Mr. Labrie, and his parents.
Did you have concerns about Owen not testifying at trial?
I did.
Why was that?
Attorney Carney's reasoning for advising Owen not to testify was because he thought he had defeated all the felonies and thought it was best if Owen then not testify. And my concern was there are still misdemeanors. Even if you think you have defeated the felonies, there are still criminal charges out there. And if you don't think you've defeated them, then you should not stop. And I had another concern, which was that he promised that Owen would testify in his opening statement. And I was concerned that the jury would hold that against Owen.
So in his opening statement, Attorney Carney had promised the jury Owen's testimony?
Yes, he'd said, promised, I guess, or maybe I shouldn't say promised. He stated in his opening that Mr. Labrie would testify and had offered that up to the jury. And I felt as if the jury would hold that against Owen and it would be bad for him under those circumstances.
Did you share that concern with Attorney Carney?
I did.
How did he respond?
He said, I can take the blame on that. They won't hold it against Owen.
Did you ultimately have a conversation with Owen alone about that?
I did.
And did that affect your relationship with Attorney Carney at all?
I believe it did. When Owen asked to speak with me privately, which I did. We spoke for some time privately. I came out of the meeting with Owen and Mr. Carney wanted to know what we had said. And I said, I'm not going to tell you, essentially. I mean, I diverted it a little bit. I didn't come right out and say, I'm not going to tell you, but I avoided answering the question. And I sensed that it impacted or probably caused a little rift in our relationship at that point.
Was that the first time that Owen had reached out to you specifically and specifically asked you to come to court during trial?
Yes.
Was he concerned?
I think so. My sense was he was.
And did he rely on your advice?
I think so.
He ultimately testified at trial.
He did.
Were you present for his testimony?
I was.
fair to say that there was a presumption that Owen would testify at trial?
I think after opening statements, there was a presumption that he would because it had been offered.
Obviously now we are more than a year past that DNA conversation
Correct.
that you had in the anteroom. And with the knowledge that you have at this point of the file that you've been able to review, the trial transcripts, the pretrial motions, the whole package of Owen's trial, do you believe that you were an effective piece of his trial representation?
You know, at the time, I would have said yes, because I think I provided what little help I could at the time. I mean, when they had a question for me, I answered the question the best I could, and I think that I gave accurate information then. Looking back at the red flags that I saw, the problems that I saw, I should have stepped in. I should have inserted myself. I should have insisted on being more active. I should have declined to be involved in those jury instructions at all, or in the alternative, jumped in and suggested things and inserted myself more. So, you know, looking back on it as a whole, I would say no. I wish I had done more.
I have nothing further, Judge. Thank you.
They just start cross-examination at this point in the
Might as well use what time we have.
That being said, though, I don't think it will benefit for us to go over. Clearly, I will not be finishing.
I understand that.
If we hold tonight, thank you. I know, I don't need to remind you, but I will on the record that you're still under oath. Thank you.
Okay.
Just to run over some housekeeping, I know you testified to previously, but you are a member of the New Hampshire Bar.
Yes.
And you are an experienced attorney.
Yes.
Approximately how many criminal trials have you tried in your career?
Dozens. I don't know exactly how many.
And specifically sexual assaults. Do you know how many sexual assault trials you've conducted in New Hampshire?
Probably a couple dozen. I did a lot when I was a public defender, so.
And when were you a public defender?
I was a public defender from 1999 until 2004, I think it was. Maybe it was 2003.
And most of the sexual assault trials that you participated in were back from 99 to 2004?
No, I mean, I did a lot then, though. So when I say a couple dozen, I've probably done maybe a dozen in private practice that have actually gone to trial. So, I mean, just cases I've handled more, but trials maybe about 12 or so in private practice. But when I was a public defender, I tried a lot of sexual assault cases when I was a public defender.
And it's clear on the record that you entered a pro hoc vice appearance in order to allow Attorney Carney to enter an appearance in the state of New Hampshire.
Yes.
And essentially, as local counsel, you're vouching for the out-of-state counsel to be able to practice in New Hampshire. Is that correct?
Correct.
And you're actually vouching that that attorney, that out-of-state attorney, is capable of handling the matters that would be heard before the Merrimack County Superior Court.
Correct.
At no time did you withdraw your appearance. Isn't that true?
That is true.
And you remained counsel of record throughout the entire trial.
I did.
In fact, the letter that you sent to the defendant when you were excused from trial actually states that you did not question the competency of either Attorney Carney or Attorney Zaganori. Is that correct?
At that time, I did not.
And you indicate to the defendant that they are experienced trial attorneys.
That was my understanding.
So just historically, you filed the original motion for new trial, is that correct?
Yes.
The first pleading?
Yes, I did.
And in the motion for new trial, you raised the claim of ineffective assistance of counsel.
Correct.
And at that time, you intended to litigate that issue on behalf of the defendant.
With outside counsel. So I did not, I had not intended to litigate it by myself, obviously. I mean, I understood there could be potential issues and I could be a potential witness. And so the understanding at that point was that DC counsel would litigate with me in case there was an issue that arose. You know, I mean, issues can arise, and if there was some kind of what we perceive to be a conflict arising, he would have other counsel.
But following the litigation of that particular issue, since that time, Attorney Malone, I've been instructed to pronounce it both ways, and I haven't been entirely certain which one was correct. But Attorney Malone has been brought on board to handle the litigation of this claim.
Correct.
But since that time, you've remained loyal to the defendant. Isn't that true?
Well, I mean, I still represent him in the appeal, technically, so I'm his attorney of record on the appeal. And I would say I remain loyal to the facts and the truth.
And is it fair to say that you would like to see him prevail on this motion for a new trial?
I think a great injustice was done, so I would like him to prevail, yes.
So you definitely have some interest in the outcome of not only this hearing, but any future hearings that may potentially be litigated.
I have an interest in seeing that justice is done.
And you stated you feel that an injustice was done in this case.
I believe so.
So you've provided interrogatory answers to the state and to respond to the questions. And you not only indicated in your interrogatories, but as well as your testimony today, that you had a very limited involvement in formulating trial strategy.
Correct.
And specifically, you said you had no conversations with Attorney Carney pre-trial regarding his method of cross-examination?
That's
No
correct.
conversations?
Well, no conversations. I did provide them, so I went to a mock trial, as I had previously testified. And when I was in the mock trial, I guess is what I mean, it wasn't the full mock trial, like all the witnesses and everything. So, but when I was in that, what I call a mock trial, I provided them notes. So, you know, jotted notes here and there. But, so I may have made points about things that I think would be relevant for cross-examination in those notes, but other than that, no.
So in your answer on your interrogatory at paragraph A4, you state, I had no conversations with Attorney Carney pre-trial regarding his method of cross-examination, areas of inquiry. So that's not 100% entirely. You
I don't know.
testified that you did provide some notes about the mock trial and the method of cross-examination.
Well, let me rephrase. I don't remember exactly if my notes from the mock trial had that or not in it as I sit here today. So I'm just trying to be 100% accurate with you. I don't know if those notes had any pointers about cross-examination. In answering the interrogatory question, my understanding of the question was, you know, did Attorney Carney and I have a conversation of what kind of points do you think I should point out in my cross-examination? How should I approach it? What topics should I avoid? We never had any conversations like that.
And you never had any conversations about the overall trial strategy, correct?
Correct.
And I believe you've also indicated that you never had any conversations with the defendant about trial strategy. Is that correct?
That's correct. Pre-trial, I had met Owen once or twice before the final pretrial. At the motion to revoke bail, the first motion to revoke bail, when we first came in as counsel. Actually, maybe the second time I saw him was at the final pretrial. I mean, I had extremely limited contact with Mr. Labrie.
But you didn't indicate anywhere in your responses to your interrogatory that you actually did have a conversation with the defendant about trial strategy of whether or not he should testify at trial. This was something new that we learned today. Isn't that true?
That was during trial. I understood the interrogatory question to be pre-trial, not during trial.
Not during trial.
Right.
So could you answer today, did you have any other conversations with the defendant during trial about trial strategy?
No. Only the one.
Only the conversation about whether he should testify at trial or not?
Correct.
And you didn't have any conversation with the defendant about the specific charges that he was facing?
No.
Or any conversation with him about the strategy for how those charges may have been challenged?
Correct.
Are you aware of conversations regarding trial strategy between the defendant and other counsel on the trial team?
I'm not aware.
And if there were, you were not party to those?
Correct.
And I believe you testified earlier as well that you were not copied on any correspondence with the defendant regarding trial strategy.
That's correct.
The first that you would have seen of those were when you received the complete file from Attorney Carney.
That's correct.
And you didn't have any knowledge of Attorney Carney or Attorney Zagori's strategies. Is that correct?
At what point?
Pre-trial or during trial?
Other than hearing openings and closing, what I saw in the courtroom? No.
So whatever knowledge you may have obtained about their strategies was based on your own observations?
At that time, yes, until I received their file.
And were you aware of the basis for their decisions at trial?
Some, I was, when I was in the courthouse and they would permit it, I would go into conferences with them periodically. So on the DNA, for instance, I had been on that conference. So bits and pieces, I think is accurate to say.
So it's fair to say that you were aware of some of the basis of their decisions at trial?
Some of them.
You have indicated in your interrogatory responses as well as your testimony here today that you were instructed by Carney to hold off on any discovery review. Isn't that correct?
Correct.
And that you were never told to review discovery after that point?
No, I inquired at least one other time in an email, and maybe other times what I should do, give me instructions, what would you like me to do?
But actually, you first suggested that you should hold off on reviewing the discovery. Isn't that correct?
No, I reached out to Attorney Carney about reviewing discovery, and his response to me was hold off.
But in that same email, and it is marked as an exhibit, and I apologize, I can't tell you exactly which exhibit number it is. I wish that I could do that. The email, March 20th. Email exchange between you and Attorney Carney on March 20th, 2015. The first part of that email sent from you to Attorney Carney at 1:48 p.m. talks about discovery, and it asks if he got a disc, and if not, I'll send it along to you, indicating, if I read from the beginning of that paragraph, it says that you received a disc of discovery from the prosecutor asking did he get the disc. If not, you would send it along to him. And then you say, I can download it into my system and send you the disc. I assume that you want me to take a look at everything, ? I don't want to incur expenses unnecessarily for Owen. If you'd rather I not spend the time reviewing it in the first instance, that is fine as well. That's the email that you sent to Attorney Carney suggesting that perhaps you shouldn't review all the discovery.
I was asking for some direction on how we were going to proceed. I mean, if, like, sometimes when you were co-counsel with a case, you don't all review all the discovery in order to keep expenses down for your clients because you're both billing a client and they're paying you. So if I'm co-counsel on a case, for instance, I just did a case with Attorney Rosenberg, he was going to do the DNA people. We split that up. You focus on these witnesses, I'm going to focus on these witnesses. So what I was looking for from Attorney Carney was some direction on, do you want me to review everything in the first instance? Are we going to divide it up? You know, so that was my inquiry.
If you'd rather I not spend the time reviewing it in the first instance, that is fine with me as well.
That disc, right.
But you've made a very direct point to indicate that this was the instruction from Mr. Carney. You've overlooked that this was your suggestion in the first place. Isn't that true?
Okay, you can classify it that way if you want to. I understood it as seeking direction from Mr. Carney.
And he agreed with you and says, please hold off on the discovery until I take the first pass at it.
Correct.
So he actually took you up on your suggestion.
I don't think it was a suggestion on my part. I thought it was for clarification. So I think we have to agree to disagree on how we're going to classify it.
You didn't want to incur any unnecessary expense for Owen, and you suggest if they didn't prefer, if you'd rather I not spend the time reviewing it in the first instance.
In the first instance,
And
correct.
Carney agreed. Your Honor, I think this is a good breaking point.
Okay? We will break for the day and we will resume at 9 a.m. tomorrow.
Thank you. Judge, can you just order that Attorney Rancourt remains sequestered and unseated?
Sure. Yes, for the record.
Thank you.
All right, please. Okay, court is adjourned.
No, these are for, I mean, I'm talking to
I'll just give them to you.
So, did you get a copy of the one now? Yeah,
Here, we're all set. Thank you.
Thanks. Did I get everything?
Oh, my God.